What's up, everybody? This is John Odermatt, the host of Felony Friday. And before we get rolling into today's show, I want to take a quick moment to talk about coffee. That's right, coffee. The Lions of Liberty, we have partnered up with Anarcho Coffee, and we are selling our very own coffee. It's called the Morning Roar. It is a medium dark roast that has cupping notes of lemon lime, caramel, black pepper, and brown sugar. It is delicious. You can pick up some of this coffee by going to lionsofliberty.com/coffee. We have a way there on your first purchase. You can get 10% off, but if you join the Pride for $10 and up, you can actually get more than that. You can get 15% off every single order. Buy some coffee, support the Lions of Liberty, support another great libertarian company as well. Everybody wins. lionsofliberty.com/coffee.
Welcome to Felony Friday, a presentation of the Lions of Liberty podcast. Here is your host, John Odermatt.
Felons, friends, and freedom lovers, welcome back to another edition of Felony Friday, a weekly show right here on the Lions of Liberty podcast. Of course, Felony Friday is the only show, at least that I know of, the only show out there where each and every single week, every Friday, when I say we, I mean I, John Odermatt, am focusing on exposing injustice in this nation's broken criminal justice system. And if you're new to Felony Friday, if you're new to Lions of Liberty and what we're doing here on this podcast network that we have, I want you to know Felony Friday is only one of 3 shows. Have a bit of a variety channel here, variety podcast feed. We kick off the week every Monday with a show hosted by Mark Clare. It is our flagship program, our longest running program. And Mark focuses on that show. He interviews leaders, thought leaders, and activists in the libertarian movement. On Wednesday, we have a show hosted by Brian McWilliams. It is more of a current events show, more of a off-the-cuff show. Brian is a comedian in his spare time, and he brings a very quirky and really interesting take on current events. He's doing a fantastic job with that show. The show's called Electric Liberty Land, so definitely check that out. These 3 shows with Felony Friday make up the Lions of Liberty podcast, and we've had this feed for a long time, several years. We're growing and growing in listeners. So if you're a new listener, we'll appreciate you if you go to where you're listening to this podcast right now, hit that subscribe button, go give us a 5-star rating, leave a nice little review, tell us how much you love us, and if you don't love us, then why the heck are you listening? Why? What are you doing to yourself? After you do that, you might want to check out, if you're not driving, of course, you might want to check out the show notes page for this episode. Because on today's episode, I'm going to be talking to 2 attorneys who are doing some fantastic things with regards to litigation and protecting people from public sector unions. So what I want you to do is go to lionsofliberty.com/FF171. That's where you're going to find the show notes page. You'll be able to read about the cases we're going to talk about today and follow right along with us as we go through each of these cases. So definitely check that out. And I don't want to take up too much of your time, so let's get rolling with today's show. My guests today, that's right, I have 2 guests today on Felony Friday, are David Osborne and Nathan McGrath. They're both from the Fairness Center. Now, the Fairness Center is a nonprofit public interest law firm that provides free legal services to those hurt by public sector union officials. First, I will introduce David. David is the President and General Counsel at the Fairness Center. He provides advice and counsel to clients and directs and manages the firm. He helped to found the Fairness Center in 2014. And prior to that, David practiced law in Florida, where he previously served as clerk to a Florida Supreme Court justice. David, welcome to Felony Friday.
Hey there, how you doing?
Well, thanks for coming on the show, man. And before we get started, before I introduce Nathan sitting next to you, I got a quick question for you on the naming of the Fairness Center.
Yeah.
Where'd the name come from? Because I think it's a fantastic name, very persuasive. Who doesn't like fair? I mean, who doesn't like fairness?
The term really came from some of the laws that at that time were sort of obvious problems for some of our first clients. The laws that were in place at that time are often known as fair share fee laws. Now, those laws have since been declared unconstitutional. We can talk about that.
Okay.
But we wanted to take back that terminology and use it for our clients.
Fantastic. I like it. So it has not only is it persuasive, it has a lot of meaning. So that's really cool. And Nathan, who I was just talking to Nathan, grew up outside of Pittsburgh. I live in Pittsburgh myself. So that's great. That's great to hear right there. Always good to talk to another native Pittsburgher.
Absolutely.
Nathan is the Vice President and Director of Litigation of the Fairness Center. He litigates and develops legal strategies to advance the Fairness Center's clients' best interests. And prior to joining the Fairness Center, Nathan was a staff attorney with the National Right to Work Legal Defense Foundation, where he practiced constitutional, labor, and administrative law. Nathan, welcome to Felony Friday.
Well, thanks so much for having us. We appreciate it.
Well, thank you for coming on the show. It's great to have you both here, and it's kind of unique. It's unique for me, at least, to have two guests, especially two guests who are in the same room. I bring on different guests, Skyping in from different locations. So I think this will be a cool dynamic. I'm really looking forward to it.
It took us a little while to make sure we were in the same room for you, so thank you.
Yeah, for the listeners out there behind the curtain, this is, I think, our third or fourth attempt, and I think both sides of us had our own responsibilities for that. But it's great to finally be speaking with you guys. And really, just before we get started, we have like 3 cases today that really we want to dig into and talk about. Really, the law behind them and sort of things that are happening with the cases. Before we do that, just so my listeners can get to know you guys better, and we'll start with David. What first really attracted you, number one, to the law, to becoming a lawyer, and then really the Fairness Center? So what was your path with that?
Well, you and I probably have this in common. I'm a big fan of the Constitution, and it's such a wonderful foundational document that I wanted to devote my life to helping people actually see the fruits of it. So for a couple of years, I worked for a member of Congress, but decided after just 2 years that what I was going to have to do was know the law myself. And so I went to law school with that goal to help people litigate their constitutional rights. And I worked in the court system for a little while, including the Florida Supreme Court. I was a clerk there, and a lot of great experience. But what I always wanted to do was this. So in 2014, when I had the opportunity, I moved my family up from Florida to Pennsylvania to start this thing. And the idea was that if we could focus on one problem where people are not getting adequate representation, it'd be this area. To explain a little bit about how the Fairness Center works, we have very, very simple mission. Our mission is to help those who are hurt by public sector union officials. We provide them free legal representation in the court of law. We also represent them in the court of public opinion. And that's an underserved market. It was before we got here. And that's because most of the time, the dollar amounts at issue are relatively small, meaning that if they went to a lawyer about even a great case, they're going to run through the value of their case in a couple of hours during a legal consultation. And so the only way that they were going to get to actually litigate their own rights was to be connected to a lawyer offering free legal representation. So that was the design, and it's worked.
So you mentioned, I think you mentioned, at least, that Pennsylvania, the location there was an underserved market. Is that right? Is there a reason why Pennsylvania and not another state for particularly serving this need?
Well, some of the laws that are in place here in Pennsylvania have been a unique harm to public sector union employees. And so I think that over time, when you don't have an organization like ours that are devoted to defending people's rights, that builds up. It starts to calcify over time. And fortunately, when we came in, all had not been lost. but our clients have seen some success.
Okay, good stuff. And Nathan, same question to you.
Right. So I guess my background starts in Western PA. And after some time, I ended up, like David, working for a congressman. I was actually down in Washington, D.C. for a number of years as a policy advisor down there. And actually, in addition to a bunch of other issues, labor was one of my issues. So I had kind of the perspective from Congress, I suppose, on that side of things. And then I went to law school. I was in private practice for a little while in Pittsburgh. And really, my next law job after that was with National Right to Work for the foundation. I fell into it not exactly knowing what I was getting into, quite honestly, and spent about 5 years there and had a national practice, got to represent just wonderful individuals around the country who have been harmed in one way or another. Often constitutional rights were impinged upon or violated. And it just became a real love for me to be able to stand with these people of principle and to offer free legal assistance where they would never have that opportunity otherwise. So after spending some time there, David got a hold of me and asked me to think about coming up this way. And after a long recruitment process, I ended up here back in Pennsylvania. Very excited to be here, and it's just worked out wonderfully. And I got to really transfer the practice I had there and the experience up here to Pennsylvania. And so I brought my family up here as well. And so we've been practicing now together for about 2.5 years here.
So I think a question that listeners might have right now, I know I have it, is free legal services. This sounds great. It's a market where this is needed. It's underserved. How do you do it for free?
We're a nonprofit 501c3 organization. So fortunately, the IRS has recognized that there's a value in organizations protecting people's constitutional rights. Mm-hmm. So we're able to raise money. We raise it from individuals, businesses, and foundations. And they are happy to help see that people are provided with excellent legal representation.
That's great. Okay, so let's start digging into some of these cases here. The first one that I have is, where is this? This is up in Connecticut, and I'm not going to give much of the background. I'll let you guys do that, but this is the IAFF Local 825 versus the Uniformed Professional Firefighters Association of Connecticut. So you guys want to start talking about this case, give some background, and then I'll ask you some questions as we go through it.
Sure. So I guess starting with our client in this case, we actually represent the union, Local 825, as we call them. And they are the firefighters of New Haven. So New Haven is a very busy fire company up in Connecticut. Some would say the busiest city fire department. There's about 300 plus of them, and just really great group of guys. And we're honored to represent them. And they, a number of years ago in January of 2016, a new administration came into office in the local union there. And they said, hey, we need to get our financial house in order. And so they started looking through the books, and they saw that they were paying, close to $30,000 to the state union, which is the UPFFA. And which is on the other side of the V in this case, the defendants. And at first they just said, this is a financial measure. We have nothing against you, but we just can't keep bleeding this money. And so, temporarily, we're going to suspend being members and not have to pay. And once we get, our finances figured out, we'll probably come back. Well, their board took a vote. Their executive board took a vote, said we're going to disaffiliate. We want to, become basically disaffiliated from the state affiliate, but they would still be affiliated with the national union, IAFF, International Association of Firefighters. And just for your listeners, that's how a lot of these unions work. So you have a national or international layer, and then you have a state affiliate that is kind of over all of the particular state, whichever one it happens to be, Connecticut in this case. And then you have the little locals who represent more particular bargaining units. So in this situation, you have a local that's wanting to disaffiliate from the state, but not the national, which is kind of a unique situation because many unions require what's called unified membership and that they're members the whole way up. So anyway, not to get too deep in the weeds, but so they disaffiliated. They took the vote to disaffiliate from the state, and the state union said, nope, you know what? You can't do that. And started fighting them on it. And they had this struggle back and forth. Our client stopped paying because they said, we took a vote, we disaffiliated, that's our right to do. And they had some meetings back and forth and phone conversations. And towards the end of that time period, about 2 years into it, the state affiliate sent our client to collections agencies, and then the collections agents started calling officers' family members and officers, really harassing things. And at that point, the president of they were sorry to interrupt you, but so they were really harassing them about just the individual dues that they owed to the state union. Yeah, exactly. So the local would collect all the money from their individual firefighters and then send it up to the state. They called it their per capita amount. Okay. And so they wanted, obviously they wanted that money, and they didn't want to let our client disaffiliate. So at that point, when the collection agency wasn't getting anywhere and getting the money back, they advised the state affiliate, UPFFA, to sue our client in court. And at that point, our client said, hey, we need help here. And so they reached out to us, and we were able to, determine that it fell within our mission statement, and we've been representing them. So we took up representation for them, filed a lawsuit on their behalf. And, I feel at this point we've served them pretty well so far. And so that's kind of the background to that case.
So we're talking, just to get the numbers, I guess, straight here, you said 30,000. I had seen a 52,000. I guess that was the continued accrued that was not paid over time.
That was the number that they had originally given because of the period of time that had elapsed. They would probably say it's more at this point.
Okay.
And so for our case, what we did, the lawsuit we filed said, well, first of all, we want the court to affirm that our client had disaffiliated properly. And then over the course of those 2 years that I was talking about, where our client and the state had argued back and forth, what our client found out was that the state affiliate and its officers had been spending money in a way that our clients didn't believe or even know that it was being spent. So instead of using it for legislative services, which is what our client signed up for, they were using it for all sorts of other expenditures, a lot of travel, a lot of meals, hotels, and paying more of the administrative day-to-day work of the union, and even collective bargaining on other local unions' behalf. So our client said, whoa, wait a second, that's misappropriation of our money. That's not what we signed up for. That's not what we're paying for. And so the lawsuit we filed actually includes a couple claims to get that money back for our client.
Okay, so it's not. So the lawsuit is more than just being able to disaffiliate. It's getting some damages back in return.
Yeah, that's correct. Our client believes that it's close to $100,000 that they've paid, basically for services that they weren't wanting to be, provided to other unions and not even to them.
Is there any precedent for a case like this? Has there been something similar that's been rolled on recently? Or
I think our case is somewhat unique in that you typically don't have a union disaffiliating or disassociating from another union. I think that's actually pretty unique about this case, and we're in some uncharted territory. The concept, though, of disaffiliation from a union has been around for a long time. It's actually what a lot of our cases is about. We actually filed 2 cases yesterday that has to do with our client, individual people disaffiliating from their union and the union saying no. So the concept has actually been around for quite some time. This particular setup in our case is unique, though.
Unique, but not totally unheard of. So there is a default rule in Connecticut, and this is similar to other states, where when a union wants to disaffiliate, they can do so freely, unless they've signed some agreement that requires them to jump through some hoops or something like that.
Right.
So So it's happened before. There was at least some really good reason to file this case and move forward with these clients.
Yeah. Yeah. And so an interesting twist in this case, after we had filed the lawsuit, the state affiliate, the state union, filed internal charges through the IAFF against our clients' officers, trying to kind of get back at them really for filing this lawsuit. I mean, that's literally what the charges were. You're, conduct unbecoming because you filed a lawsuit against us and you've talked about it. And so that started moving on its own tracks through the union system. And we went into court for a preliminary injunction, which basically we're asking the court to put a pause, hit the pause button. That's what that means. Mm-hmm. And so the court, after some back and forth, 4-day hearing, actually, the court sided with our client and said, yeah, you know what? You've got to put that other proceeding on hold until we figure out this issue first. And then you can go forward with it after that. But so we've already made some ground for our client, but it was just really interesting the tactics that they were taking because they were angry about, our client trying to exercise its right to leave.
Yeah, this is a really unique case. I mean, the more I think about it, the aspect of a union, it's like a union within a union. So it's an organization within a larger organization. And then you have the internal, disciplinary ways that they can, that's fascinating.
There's a lot of moving parts on this case. So we're regularly thinking about how it all fits together. It's a big jigsaw puzzle.
What's the timetable on it when you think there'll be some, I know it's hard to predict maybe, but is there a timetable when you think there'll be a resolution of some kind? Yeah,
I mean, actually in this case, the court has put out a scheduling order and the actual trial for it all, if we make it that far, is set for September of 2020. So the wheels of justice are moving slowly in this case, but we'll get there.
Moving slowly, but they are moving. So
they are moving, indeed.
That's good news. Yeah. Let's move on to the next case here. So this one's interesting. I'm going to have some questions about it. Just really, I'm not sure if I really understand what happened here, but that's why you guys are on the show. So this is the Kiddo et al. Versus the, what is it, AFSCME Local 2206? Did I say that right?
You got it. Yes, the American Federation of State, County, and Municipal Employees.
Right on. So we have the Fairness Center, you guys representing 8 of the Erie Waterworks employees, right? So what's happening in this case here?
So this is a good example of another kind of case that we've litigated for individuals. We represent 8 public sector employees that work for this city water authority. And their story really starts back in January of 2018. Mm-hmm. 2018? Yeah, 2018. Yeah. In January 2018, these folks go to a meeting put on by their union, AFSCME, and the union representatives get up in front of all the union members, and this is something that probably a lot of union members have experienced. They present to them a contract for ratification. This is a contract that for the past few months, sometimes longer than that, the union has been negotiating with their employer. Mm-hmm. And employees are actually excited to see what's in it. Sometimes they have high expectations about what their union has been doing for them all this time. Our clients were very disappointed at that meeting. And the reason they were disappointed at that meeting is that they had told the union that they wanted certain benefits. Mm-hmm. And some of these benefits had actually been offered to other employees at the exact same facility who are in different bargaining units with different unions. And those benefits were not available to them under the contract that the union presented to them. So they started to ask questions. So where's this thing we wanted? What they wanted was something called a post-employment subsidy. It would have given a little extra money to people after they retire, but before they hit Medicare age. Mm-hmm. So where is that? Some of us are looking at retirement. Well, we told you we wanted it. Where is it? And the union said, it's not available. And if we have to go back to the bargaining table to get it, you never know what'll happen. In fact, you could lose your pensions. Now that's That's a scare tactic.
Yeah.
They started to look around and say, what do you mean we'll lose our pensions? And it was clarified that no, maybe just that girl will lose her pension. So it turned into actually a very heated meeting where the employees left, one of our clients left crying because some of the plans that she had for retirement were just not going to be realized. Well, just a few days after that meeting, they get a letter from their employer, and the employer tells them, it's come to our attention that you learned about some of the options that were available during the negotiation period, but there was actually a whole nother option that was available to you that included the post-employment subsidy. It also included a higher raise, and the only concession that we asked the union to make was to move new employees, not you, new employees, onto a defined contribution plan. So all these employees are suddenly thinking, wow, why did the union hide this from us? Mm-hmm. Well, the reason, come to find out, that the union hid it from them, is that the union was so self-interested in the pension plan and continuing that even for new employees that they refused to even share with existing employees a better offer. So these employees wondered what to do. By that time, they had not found our organization. And so what they did is they hired a local lawyer. And this is the problem I was mentioning at the outset of this. This local lawyer did some work for them, filed internal union charges. Sometimes you have to exhaust these things before you can go to court. And but they ran out of money. And so when they ran out of money, they started looking for someone else who could do this. And they found us. And we ended up deciding that just as with Local 825, they fit our mission. What they wanted to do was to go back, to roll back the clock and revote on this thing with full knowledge of the two options. Mm-hmm. So the legal theory behind this case is something called the duty of fair representation. Okay. A long time ago, the courts decided that if unions were going to be exclusive representatives, that is, represent everybody in a particular bargaining unit, they were going to have to do it fairly, because at that time, unions were especially guilty of racial discrimination and other sort of horrors of that time period. And so the courts imposed on them this duty of fair representation, that if you're going to represent everybody, you got to do it fairly. Over time, that has been interpreted as including, not just prohibiting discrimination, but also treating all the members fairly, reasonably, with due care, very much like a fiduciary duty, if you're familiar with that. Mm-hmm. So this duty of fair representation was violated here in really a couple of different ways. One, the union actually hid this offer, this option from their employees, and concealed it when asked about it. They basically misrepresented to employees what the options were in front of them. And then second, they've actually imposed a higher standard on themselves. There's a provision within AFSCME's own constitution that's called a Bill of Rights for members. And this Bill of Rights for members says that members will have the right to participate in the decision-making process of the union. And along with that right goes the right to receive all information that's pertinent to exercising that right, including information, and I'm not just making this up, this is all in the Bill of Rights, including information like the acceptance or rejection of past offers. So the problem for the union here is that they've treated their members unfairly, and they've imposed that higher standard on themselves that makes it it's basically like a promise to members that they've broken. So we went to court for them. We actually just won a preliminary injunction as well in that case to stop everything where it is. Right. As part of that analysis, the judge has to determine that we have a likelihood of success on the merits of that claim. So our clients are feeling very good about that one right now. And we're in position right now to sort of drive the ship and hopefully get what these clients have been looking for.
So would winning that case be, simple is not the right word, but be as direct as getting a revote on those plan options, or is it more than that?
We've asked for a couple things. That's what I'd call like an equitable relief claim. Mm-hmm. We want the court to figure out some way to make these people whole. It's not financial, but if it's not that, then there's the remedy for a breach of the duty of fair representation is damages against the union. So we can calculate the damage to these members that has occurred as a result of the lies that the unions told them.
Yeah, I mean, I guess they could be pretty extensive when you're talking about finances like that, especially with pensions involved, for sure. Mm-hmm. Okay, so moving on to the next case here. So this one is in Pennsylvania, right? I believe. Francisco Molina versus the Pennsylvania Social Service Union, the Service Employee International Union, the SEIU, and Local 668. So so this case has to do with, this sort of sounds familiar. Maybe I've seen cases like this before with Mr. Molina being a member of the union and a little bit of tactics of force or intimidation being used to try to get him to sign a union membership card, and him not agreeing to do that. So what's happening with this case?
Yeah, jump in if I'm explaining this the wrong way. Okay. But remember I told you about the Janus case. The Supreme Court decided last year that non-members should not have to pay for the union's representation if they don't want it. That got rid of this thing called fair share fees in Pennsylvania. Well, back in also 2018, January 2018, the union, Mr. Molina's union, which is in Lehigh County, started to see that maybe the Janus case will get decided against us. Maybe we won't be able to collect fair share fees anymore. So they came up with a new card, and you're right. There are these new membership cards that are making their way across the country, and the membership card would have obligated members to pay dues or the equivalent amount, regardless of membership status. It sounds tricky because it is.
It doesn't sound right. That's for sure.
The idea is even if they resign their membership, the union's saying that they still have to pay their dues. Now that's dubious in itself, but that's what the card said. And Mr. Molina also thought, and I think he was accurate, say that would actually mean if he left his job or if he transferred to a non-union side, maybe he'd also have to pay dues in that circumstance. So he didn't sign the card, and he told a lot of other people within his bargaining unit not to sign the card either, or at least to read it before they did anything. And it was only 6 months later that Janus was decided by the Supreme Court, and Mr. Molina went. Fortunately, he had not signed that card because his case would have been even more complicated. But he decided shortly after Janus was decided to resign his union membership. The way you do that is you send a letter to your union and you tell them that you're resigning your union membership. Not terribly difficult. But after he filed that letter, it was only a few weeks later that he was dismissed from his position. He was basically a social worker with Lehigh County in Pennsylvania. Dismissed from his position, and they never acknowledged his resignation letter. The union never stopped taking dues out of his paycheck, and they never refunded him those dues, at least at this point. So Mr. Molina is thinking, what am I going to do? How am I going to get that back? In the meantime, he's also filed for arbitration. He's trying to get reinstated and get back pay from what he feels like was an unjust firing. So Mr. Molina came to us and said, what's going on here? What were my rights? And we eventually filed a case for him. And here's what the case is about. We filed a number of other cases like this in Pennsylvania because apparently it's an issue. Mr. Molina should have the right to resign from his union whenever he wants. There's a law in the books in Pennsylvania that says you cannot leave your union for years at a time. That is until the last 15 days of your collective bargaining agreement. So if you were to become a public employee today and you're bound by a collective bargaining agreement that runs through 2023, that would mean you would need to go to your Google Calendar and mark off the last 15 days of the contract period in 2023, so that you could be reminded to go and send a letter to your union. In the meantime, during that whole time period, you would have to support an organization with which you disagree.
So you only have essentially 2 weeks.
Yep.
At the very end. Wow.
And a lot of these contracts, that David's talking about, they run anywhere from 3 to 6 years. These are not short periods of time that you're like, oh, just stay in another month and then we'll let you out. These are long-term deals that this provision is put into.
So that should be unconstitutional. And so back in the private sector, back in 1986, there was a case that said private sector employees and unions could not do this to people. Now, it wasn't a constitutional decision because these are private sector, but what it said was it's contrary to Congress's intent in the National Labor Relations Act. Basically, in my view, doesn't serve labor peace to have people involved in a union they don't even want to be a part of. So that has never been explicitly applied on the merits in the public sector, interestingly. There have been some cases that have gone as far as preliminary injunctions where they've gotten the same kind of ruling we're talking about in some of our other cases where we are likely to succeed on the merits. Other public employees have raised that very claim and have been likely to succeed on the merits. But no case has gone all the way to the merits on that. So Mr. Molina wants a ruling definitively that he has the right to leave his union at any time, not just the last 15 days of a contract period. And he wants his dues back. He's also made the claim that he should be able to get his dues back even further, back to the statute of limitations, because the union has essentially been taking his money. Remember I told you they wanted people to sign new cards? The reason they gave was they said the old cards are invalid. So that was either a complete hoax or they're accurate. And the old cards are invalid. But if they are, he should be able to get his money back from that time.
Right. So this is against, like we talked about it in the first case, sort of like the local, the state, and the, I don't know, what are they, national level union?
Yes, yeah. Yeah, very similar. And a lot of people who are trying to leave the union face the same kind of problems that the local 825 union faced when it tried to get out. And I don't think you mentioned it, but they were actually in Connecticut in the local 825 case. The union, the bill collector that was enlisted by the statewide union was actually contacting local union officials, elderly grandparents, like looking for contact information for these people. The same way bill collectors do with anybody else.
Wow.
Just flip open the phone book, go down through everyone who's, similar last name. So, yeah. And this is really a problem. What David was talking about, the law in Pennsylvania is unique. I think early in the conversation, he was talking about an environment in Pennsylvania. And Pennsylvania is one of those states that actually built into the law. There's this restriction on, escaping your union if you want to. And so it has led to a fair number of cases here in Pennsylvania where we represent clients who, that's all they want. They just want, the freedom of association. They want to leave their union and be done with it and not be forced to pay for, representation and activity that they don't agree with or support.
Well, we're talking about it very clinically too, because we understand what the law is on this issue. But for a lot of these folks who come to us, all they've really encountered is I tried to leave and the union said I couldn't. Is that true? They actually do not know the answer to that, because when they go to the statutes, there's a law in the books that says unions can do this kind of thing. When they go to the collective bargaining agreement that the union has come up with their employer, it says that they can be kept in the union until the last 15 days of the contract. So they're not presented with information that's accurate, and they don't know the experiences of some other people who've actually faced the same kind of problems.
And when they try to get out, or they try to ask the union for assistance, or, hey, is this true? Or when can I get out? The union does everything from just doesn't respond to them for months to send them letters to say, well, just look at your contract and figure it out. And we'll recognize you maybe if you follow that procedure. They'll go to their employer. Oh, this is a good one. They go to their employer and say, hey, looking at this in my contract, what does this mean? Can I get out of the union? And the employer says, yeah, you're going to have to talk to your union about that. And so the whole cycle just happens over and over again. We've had clients who for years tried to just get an answer, and they haven't been able to get an answer until they found us.
That's just absolutely crazy. I guess it's not crazy because it sounds pretty common that this stuff does happen. But are there any other organizations like yourself, like the Fairness Center, doing similar work in the United States for free?
Sure. I mean, National Right to Work, where Nathan came from, has been doing it since 1968, something like that.
1968.
So they've been real leaders in this kind of law. So yeah, it's been around. I think the way that we can distinguish ourselves from the work that they've done is that we're focused on 2 states, Pennsylvania and Connecticut. Okay. And instead of having sort of a national perspective, we're able to see some of the nuts and bolts in each of these states that are hurting people. And it gives us a little bit of an edge, at least in these states.
One thing you said at the very beginning, I forget which one of you said it, that not only are you fighting these cases legally, but also I think you said from a public relations standpoint.
Sure, yeah.
So what are some things that you would do from that view?
So in our view, that's part of being a lawyer. It's representing people, not just in court, but in the court of public opinion. When you don't litigate cases that are going to ultimately hurt your client if they're trying to actually operate a business, Right. With these folks, they have relationships. They have particularly relationships with their employer, with other employees. They have a relationship ultimately with the general public who they need to think well of them in order for them to do their job. So you want to give some examples of the stuff we've done in that?
Sure. I think the example that I often give to people, we have a line of cases we call the ghost teacher cases. And just real briefly what that is, the unions will negotiate for its members or officials to go on what's called union leave time. And that means they go and they work for the union while still receiving their pay, their benefits, their seniority, their pension credits from the public employer. So it's, for instance, take a teacher who's also the local president of the union. Well, the teacher will go and leave the classroom and not even show up for years to teach, and they'll work full-time for the union, but be paid as if they were a teacher there and get pensions as if they were teachers there. And so it's pretty amazing. It's one of those things where, this isn't a partisan thing. Everyone I've ever talked to about this across political lines or ideological lines has said, well, that kind of sounds a little slimy. And we agree. And so we filed several cases on that. And the cases are still slowly working their way through the court system. But what is so neat and unique about how our law firm approaches this, the court of public opinion, we publicized our cases. Other organizations kind of picked up on what was going on and said, hey, there needs to be some policy research done on this. And legislators said, maybe there's a legislative fix. And so between all of that momentum that really built in public, the court of public opinion, we've seen across the Commonwealth here, school districts and unions have really reformed their ways on that. And so we've achieved widespread change for our clients, which our clients wanted to achieve, but not yet through the courts. It was through the court of public opinion. And that's how we really see the value and power of being public with these cases, as well as being good attorneys. Again, our clients tell us what the ultimate goal is, and we figure out how to get them there. And this is one of the ways we do that.
And so we filed a case for one of our clients yesterday and announced it today, and included, along with the announcement, a video of him talking a little bit about his case. It's very compelling. It's a guy named Curtis Thompson. He, sort of like Francisco Molina, was prevented from resigning his union. And he had been dealing with that for years. So putting that video out in the public so he can really explain for himself why this thing is filed, I think is really important. We've also testified. Right. You mentioned legislation. We've testified in the legislature for our clients to make sure that the legislature understands the issues we're dealing with, and the law can go the right way. Number of things. I mean, if it's for clients, we'll we'll put ourselves out there.
Yeah, well, that's awesome. I think that's so important, especially in today's world where people are sort of, I think they're expecting to see a little bit more of the personal story, seeing, sort of the behind the scenes, the reality TV of really what's going on because they're used to going on social media, Instagram, Facebook, and being able to see, little short stories, things like that. Mm-hmm. So that's very, very important. So I'm glad to hear you guys are doing that. And I think I'm on the Fairness Center emails now, so I'll do my best to help draw some attention to the cases as best I can. Before I let you guys go, if you could just give our listeners and viewers one more time where they can find out more about the Fairness Center, where they can maybe get involved and donate to help fund you.
Go to our website. It's like all of the above. fairnesscenter.org.
All right. Sounds great. Well, thank you guys both for coming on Felony Friday.
Thank you.
Sure thing. Thank you.
Are you tired of banging your head against the proverbial wall of politics and getting nowhere toward actually making your life more free? Are you tired of interview podcasts that have the same guests as every other libertarian interview podcast out there? Are you tired of hearing the same news stories that you can hear on the mainstream media? Then you need to listen to The Lava Flow, where we don't do politics and we don't do the major stories that exist only to divide you. We talk about news that affects you and your freedom, and we work to find solutions that can actually help you to be more free. Check us out at thelavaflow.com.
Listen to Weird Libertarians at weirdlibertarians.com. My name is Chris Spangle, and I host a show where we talk about the stories you and your friends are talking about, and then we give you libertarian solutions so you sound smarter when you're talking to your friends. We're going to make you sound like a genius. Tune in now at weirdlibertarians.com.
Are those dry, boring, run-of-the-mill political talk shows putting you to sleep on your commute or at work? Are you ready for some fun?
Look no further. Blast Off with Johnny Rocket is a Seattle-based podcast expressing viewpoints of free markets, voluntary exchange, badass music, wicked banner, and of course, drinking.
The Blast Off doesn't shy from the truth, but always brings the party.
Let's rock and roll, Raylene.
Bring it on, Johnny.
You can check us out at thelaunchpadmedia.com/blastoff.
Again, that's thelaunchpadmedia.com/blastoff.
Launchpad Media. Always launching ideas in your direction.
Thank you guys for listening to today's episode of Felony Friday. Another great show, some great content. I want to thank my guests, David Osborne and Nathan McGrath of the Fairness Center. Hopefully, brought me some great insight. I enjoyed it. I enjoyed hearing about these cases and knowing that there's an organization out there that is fighting for people, protecting the individual against these public sector unions. And, it's no secret. I think most people out there who have their eyes open and don't have their heads in the sand understand that, there are some nefarious actors out there in public sector unions, and it's not all for the all of their actions are not for the goodwill of the people. And there's certain things when you're going to need people to step up and step in, lawyers to step up and protect you from these actions when a union does not have your best interest in mind. And that's not to say that I'm always anti-union or always against unions or against the concept of unions. Free association and consensual relationships and all those types of things are all fine and well and good. But when you get into different situations where there is coercion involved and there's language that is confusing and it's hard to opt out of a agreement or a contract that you've signed, and maybe you were misled into signing it or forced into signing it in a certain way, it's very important to be able to protect yourself against those types of situations because they can be very confusing and you can feel like you are against the world and there's no way out. So that is why I'm thankful there are people like David and Nathan who have literally dedicated their lives to protecting individuals against unions when these things happen. Like I said, not all unions are bad. But very often with public sector unions, these types of things do happen over and over again, and it's not a coincidence. It's inherent in the public sector union. And that's probably a story for another day to talk about. But for this episode, I want to wrap it up and just thank David and Nathan one more time. I just want to remind you guys at the top of the show, very top of the show, I talked about our newest offering that we have through Lions of Liberty. We actually have our own brand of coffee, partnering with Anarcho Coffee with a awesome tasting coffee called the Morning Roar. If you haven't checked it out, please consider doing so. If you drink coffee, why would you not drink a delicious, tasty coffee and also help out two fantastic libertarian enterprises? One of them being Lions of Liberty, the show you're listening to right now. The other being Anarcho Coffee. So the way to do that, the way to support both, is you have to buy through our link at lionsofliberty.com / or I'll just say lionsofliberty.com/coffee. Go there, click that link. That's our affiliate link. That makes sure that we get a little bit of the commissions from the sale of the coffee. And that's the reason why we're promoting the coffee, really, is to get those commissions. So please, go and click the link. We would appreciate it very much. And with that being said, guys, you can get I should add, before I let you go, before I sign off here, you can get a greater discount on the coffee. You'll see on the site there when you go to lionsofliberty.com/coffee, you'll see you can get 10% off with the code there on your first purchase. If you want to get continuing on every single purchase, 15% off, you got to join the Lions of Liberty Pride at $10 and up to get access to that code. That's $10 per month that you would subscribe to Lions of Liberty Pride. So you're going to get the coffee code, 15% off. You're going to get a bunch of other stuff, merchandise. You're going to get access to our bonus content, all that great stuff. You can read all about it at patreon.com/Lions of Liberty. That's all I got for today. Thank you so much for listening to this very, very important episode of Felony Friday today. This is John Odermatt signing off. Always remember to keep your head up and the fires of liberty burning.